Hello, and welcome to the newest edition of Nelson Mullins' 2021 Education Law webinar series. Thank you for joining us today. My name is Dan Cohen, and I'm a partner on Nelson Mullins' Education Law team. Nelson Mullins is an AmLaw 100 firm with about 800 attorneys and policy advisors across 25 offices in 11 states plus Washington, D.C. Among other practices, we have a dedicated team of attorneys focused on serving all legal needs of educational institutions, including in the areas of labor and employment, healthcare and issues affecting academic medical programs, construction and real estate, intellectual property, privacy and information security, and unique issues affecting education institutions like student and faculty discipline, sexual misconduct, and athletics. We host free monthly webinars addressing legal topics across these areas and sometimes more frequently as issues arise. Please feel free to contact one of our education attorneys if you have any questions about our webinars or any other legal issue affecting education institutions. Today, Marquetta Bryan is going to focus on preparing for post-pandemic activism. The COVID-19 pandemic highlighted many of the inequities in our society and increased calls for actionable change. This fall, we can anticipate the possibility of student activism and/or protests on our campuses. Marquetta will provide the legal framework for K-12 and higher education institutions as they re-examine policies and practices and prepare for post-pandemic activism this fall. Marquetta Bryan is a member of the Nelson Mullins education team in Atlanta. She focuses her practice on employment law and litigation, policy and governance, compliance, and investigations. Marquetta has over 18 years of experience representing exclusively employers, including K-12 clients, institutions of higher education, both public and private, and other nonprofit entities. And her experience covers discrimination matters, wrongful termination, harassment, and retaliation cases. Marquetta works closely with employers to develop best practices and legal strategies in managing employee and student relations that support mission and business objectives in efficiency in operations. With that, I will turn it over to Marquetta.
Thank you, Dan. Good afternoon. I'm so excited to be here with you today to discuss this topic, which I think is very, very timely and relevant. Amidst the global pandemic, a presidential election, and a variety of social movements, we are in the midst of the most perfect environment for a number of First Amendment issues to arise in our schools and college campuses. From social movements such as Black Lives Matter to Make America Great Again, the sheer magnitude of the societal and political forces at play have increased tensions and spurred demands for cause and change, including from our educational institutions, from elementary schools to college campuses. The COVID-19 pandemic and the political and social landscape has had a significant impact on communities across our nation and abroad over the past year. And as more and more of our students return to an in-person environment in our secondary schools and in our colleges and our universities, such issues will inevitably make their way through our school doors, in our campus dormitories, and also in our virtual learning platforms and social spaces that we share. So the question for our conversation today is, are your school districts and your colleges and universities prepared? The pandemic has brought into sharp relief the fault lines of inequity that divide our world. We have all heard it before, and the world was somewhat forced to be a captive audience of the realities that exist, and that includes our students, our teachers, our faculty, and our administrators. Protesting is nothing new. Protesting takes on many forms. It can be speech, it can be silence, it can be shows of expression, including taking a knee, protesting lunch, and even walkouts. Protests have played a major role in our country in shifting both our policy and our public opinion about issues like civil rights, LGBTQ issues, elections, climate change, and even how our schools have handled the COVID-19 pandemic. So I think what we'll see, at least, is that 2020 has formed or galvanized a generation of young people, younger and younger actually, that understand their right to protest and what's happening in our nation, and that want to try to create social change. This is a great time for us to talk about and refresh ourselves on the legal framework around principles of free speech and freedom of expression under the First Amendment. This is a broad yet comprehensive topic, so if there's something that we don't discuss here with you today, or that your organization doesn't hear and you need assistance with, please feel free to reach out to me or any of our education attorneys here at Nelson Mullins directly, and we'll be more than happy to partner with you as you consider best practices in your own organization. As Supreme Court Justice Robert Jackson wrote in 1943 about the role of schools in our society, he said that they are educating the young for citizenship is reason for scrupulous protection of constitutional freedoms of the individual. If we are not to strangle the free mind at its source and teach youth to discount important principles of our government as mere platitudes. So I want to start by talking to you about the principles that provide the legal framework and backdrop for understanding and doing a First Amendment analysis for the things that we anticipate that you may see this fall as you reopen. I'll start just by saying that for purposes of this webinar, when I use the word schools, I intend to encompass both K-12 and institutions of higher education, unless there is some reason that I need to make a very practical distinction of both of those institutions. Now, the First Amendment of the Constitution of the United States just very basically protects individual freedoms from government interference. So as a general rule, it does not protect individual freedoms from interference by private organizations, such as private colleges and universities. So in some, private universities are free within the law to define their own missions, and some would argue to restrict academic freedom on behalf of whatever religious or particular agenda that it subscribes to. However, most private, I think, and secular colleges and universities would consider themselves to be havens of free expression, religious, political, and cultural, and in fact have traditionally chosen to allow greater freedoms than public universities, protecting far more than the Constitution requires. Private institutions do not face those same constitutional restraints that public institutions do. Universities, colleges are an important institution in any democratic society. They foster the development of students into autonomous individuals and encourage the exchange of conflicting ideas. However, racist speech, hate speech, and expression may pose a threat to the missions of these institutions by disparaging particularly minority students and limiting their potential for self-realization. A seminal case in this area, as we start to talk about what the backdrop looks like, is Tinker versus Des Moines Independent County School District. And so what I want to do is kind of give a backdrop of some of the practical considerations that courts have looked at in this analysis, and so that we can start to develop the framework that you will refresh yourselves of and look at as you're looking at your policies, re-examining your practices, and how you respond to First Amendment issues of speech and expression that come up in your organizations. Now, this is a 1969 case decided by the Supreme Court. And in that case, the court held that a school district may only regulate student speech if the district can show that the student speech would cause a substantial disruption, or if the school district could forecast substantial disruption or material interference with school activities. Now, in looking at these things, what we're anticipating is that we will discuss the legal framework for what you will need and some of the scenarios for what we think you will encounter or you will likely encounter while providing legal guidance and practical considerations for response as your students return to campus. So the Tinker case, which has been called the Tinker test, provides that, again, speech can only be limited for actual substantial disruption or a forecast of substantial disruption. Now, in 1968, just a year before Tinker was decided, in the case of Bethel School District 403 versus Frazier, the Supreme Court held that a school district may regulate speech that is considered vulgar, offensive, lewd, and indecent, regardless of whether the student's speech creates a substantial disruption. Finally, the Supreme Court held in 2007 in Morse versus Frederick that a school district may regulate speech that promotes illegal activities. So I'd like to just give you an example of what applying these principles might look like in practice. So, for instance, can a school, in this context, prohibit a student, particularly say the K-12 context, prohibit a student from wearing apparel that features social and political messaging, which may be conflicting, it may be something that is contentious, but let's look at what the courts have told us for those three cases that I've given you. So applying the First Amendment framework principles that I just discussed, a school district likely will not be able to prohibit student apparel featuring social and political messages unless the apparel in question has, under the Tinker case or test, caused or is reasonably likely to cause a substantial disruption. Or, as advised in the Bethel case, if the image or messaging is vulgar, offensive, lewd, and indecent. Or, based in the Morse case, if the speech promotes illegal activities. So generally speaking, a shirt, or depending on your reopening plans, even a face mask worn by a student which supports some political ideology, no matter how contentious it may be, or even a particular political candidate, will be protected under the First Amendment. Now, notwithstanding the above example and the frameworks that I've just set out, I do recommend that schools proceed with caution in applying the Tinker substantial disruption standard to student attire. Why is that? Because the basis for determining what would actually cause substantial disruption, or the forecast as to whether some speech or expression might cause substantial disruption, should not be simply a singular, subjective, or even narrowly focused, emotionally driven decision. Administrators have to actually demonstrate facts that might reasonably lead them to forecast substantial disruption or a material interference with school activities before prohibiting a particular expression of opinion. So what that means is that a clothing item that merely makes others uncomfortable or upset will generally not meet the substantial disruption standard established by the Supreme Court in Tinker. Now that I've actually offered some insight on the basis of First Amendment principles to rely upon, I will give some examples of the type of speech that has actually received First Amendment protections to help us illustrate what type of speech has received these protections, specifically what courts have held schools were not legally able to prohibit students from wearing. So I'll start with the Tinker case itself, because in that case, the court found that a school could not prohibit students from wearing black armbands that showed their disdain or from protesting the Vietnam War. And this is also helpful, this case, right off the heels of a presidential election and in the midst of local elections that get more heated in some areas of the country than others. A 2003 Michigan District Court held that a student could wear a t-shirt with a picture of a US president and the words international terrorist. And that case is Barber versus Dearborn Public Schools. Additionally, the Fourth Circuit in a 2003 case held that a t-shirt with an image of guns supporting the National Rifle Association worn by a student was also protected speech, and a school could not prohibit that. That is the case of Newsom versus Albemarle County School Board. So the takeaway here is that if speech is protected under a First Amendment analysis, much like what we've done here in demonstration today, then a school district may not regulate the speech by banning the apparel in question. However, if the speech is not protected by the First Amendment, then a school district may prohibit the student from wearing the item in question. And a school may follow its regular student discipline policy for any refusal to follow such directives. The key in following policy, however, is to make sure that students are not disciplined more harshly for content than students would for other non-content infractions. So again, as I stated, we'd like to just anticipate some of the things we imagine that you will encounter or that you're likely to encounter as you reopen your doors to students more fully in person. So what about speech that seemingly invites violence against members of a campus or school community? Does the First Amendment protect that? There's a Supreme Court case in Brandenburg versus Ohio that held that government can actually not punish inflammatory speech unless it intentionally and effectively provokes a crowd to immediately carry out violent and unlawful action. It's a very, very high bar. And so this is called the incitement standard, and it has been used to protect all kinds of political speech, including speech that at least tacitly endorses violence, no matter how righteous or vile the cause. For example, in another case where this was explored, NAACP versus Claiborne Hardware, the court held that civil rights icon Charles Evans could not be held liable for the statement, "If we catch any of you going in any of them racist stores, we're going to break your necks." There was another expletive in there, but I think you get the point on how the speech seems to seemingly suggest that there will be violence. In Hess versus Indiana, another case, the court held that an anti-war protester could not be arrested for telling a crowd of protesters, "We'll take the effing street later." And even in the Brandenburg case, the court held that a Ku Klux Klan leader could not be jailed for speech stating that there might have to be some revengeance taken for the continued suppression of the white Caucasian race. Again, students don't lose their First Amendment rights at the schoolhouse doors, but we also understand that our priority is to keep our students safe and to try to facilitate the exchange of ideas. So as we continue to talk about the backdrop, we'll also talk about some of the best practices and considerations that school and campus administrators should employ as they're reevaluating their First Amendment policies as they move into the fall semesters. We do recommend that you take this time during the summer months to reevaluate your discipline policies, particularly to ensure that if they don't impose in language or in practice, that they don't impose in language and practice any harsher penalties on speech and expression related than they do for other incidents, that they don't find themselves disparately impacting or imposing harsher penalties for content, as opposed to, like I said, those other non-content related infractions. We also recommend specifically that you partner with your legal counsel regarding any fact-specific First Amendment analysis, which we recommend in all cases if you have that time, before pulling what can end up being a very costly trigger and result in lengthy and costly litigation. Now, before I transition from this topic of what free speech and expression looks like, particularly in terms of what students may wear to campus and in classrooms, I want to make sure that I also discuss this in terms of the staff and teacher administrative context, particularly in the public school district arena, where our teachers, just as our students, are also fired up and are galvanized to pay attention to what's going on for what they feel like are unfair treatment or injustices, even in the education context, even in protesting their own employers. Over the years, our courts have ruled that school employees are not always free to express their opinions and beliefs. However, employees cannot be disciplined or suffer negative consequences for speaking out on matters of public concern. On the other hand, schools can take action when employees go public with what's considered strictly personal concerns. To give the backdrop of how we've looked at how we discipline or how we address speech from faculty in the First Amendment context, there's a Supreme Court decision from 1968, Pickering versus Board of Education, which held that freedom of speech, while not absolute, gives public employees constitutional protection if they are, again, speaking of matters of public nature, rather than those things about which they have a personal stake. In Pickering, the court overturned a school district's decision to actually fire a teacher for commenting on school expenditures, which is, say, different from a teacher complaining about how they may not like the way their principal is treating them exclusively. And so this particular teacher did this through letters in a local newspaper, finding that school expenditures are actually a matter of public concern. Now, as the court stated in Pickering, a balancing must be struck between interest of the employee as a citizen in commenting on matters of public concern and the interest of the state as an employer. So again, we do recommend that there is a factual analysis whenever an issue like this arises, and that there is some partnering and discussion with legal counsel to aid you in going through the First Amendment backdrop that we have from the case law that is well established. This is not an easy task to do. Based upon this balance, however, it's commonly understood that school employees can be disciplined based on their expression, like publicly criticizing supervisors, if the school believes that it will impede the employee's ability to perform assigned duties. But again, as I've advised in applying the Tinker substantial disruption test, I advise that there's a careful analysis here. Or that the speech will undermine supervisory authority, disrupt the school, or actually destroy close working relationships. Again, that can be a delicate test to determine. There's also another case, and it's a little bit later. In 2006, the court refined the public employee First Amendment analysis when it ruled in Garcetti versus Ceballos that when public employees make statements pursuant to their official duties, they are not actually speaking as citizens for First Amendment purposes. And the Constitution does not insulate them from their communications from discipline. So in sum, when we're doing an analysis in the school setting, if you are confronted, particularly in the public school district context, with an employee with a speech case, the court's analysis based on the backdrop looks something like this. Is the statement made pursuant to the employee's official duties? If so, the employee may be subject to disciplinary consequences. Is the speech a matter of public concern? If not, the employee may be subject to disciplinary consequences. If so, was the employee's speech outweighed by the school's interest in promoting efficiency in the delivery of educational services? And it's important to note that the court has said that it is not necessary to allow events to unfold in the extent that there's a disruption in the office or in the school, inefficiency in operations, or destruction of relationships before action can be taken. So that is important. As with students, if this disruption to the educational enterprise is foreseeable, if it's actually foreseeable, action may be taken to circumvent that disruption. So applying the case law to the public school, say even athletic activity, the following are likely conclusions under a First Amendment analysis. So let's say, for instance, you have a head coach, an assistant coach, or a volunteer, or even an other athletic employee of the school district who kneels, like a Colin Kaepernick, or otherwise fails to participate in the national anthem, would be engaging in speech while performing his or her job duties. A coach's status as a school employee engaged in their job duties would be enhanced by the fact that they would likely be wearing school clothing or equipment that identifies them as a school employee particularly. Community members would undoubtedly view this person as a school employee, and so therefore it's highly likely in this example that a coach is speaking as an employee and not as a citizen. But again, we want to make sure we do a careful, exacting analysis. So while staff members generally have the right to speak as private citizens on matters of public concern, in the Garcetti case, as we've been told, statements made by staff members pursuant to their official job duties are not protected by the First Amendment. Also, in the case of Meyer versus Monroe County School Corporation from the Seventh Circuit, that court held that the First Amendment also does not entitle a teacher to advocate for a particular viewpoint while teaching to a captive audience. That allows me to transition to another scenario that you might encounter, which is, what about if a teacher wants to engage students about their particular viewpoint? What if a teacher wants to post signs for their own particular beliefs in the classroom? Black Lives Matter, Make America Great Again. Maybe they want to take a stance or take a side in the Israeli-Palestinian conflict. How do you address those things? What if a teacher who's teaching virtually has a visible display in their background, or somehow these messages of social and political ideologies make their way into the virtual platform? I would suggest here that we use the same analysis in looking at what is the impact of this. So for instance, teacher-led discussions on a particular subject. Teacher-led discussions during class time regarding the state of politics in the US might be appropriate under certain circumstances. School districts, however, and not necessarily moving to discipline or infractions first, there's just a level of conversation that's warranted between administrators and faculty as to what is expected. So for instance, school districts in this case should do a couple of things. They should ensure that discussions only occur in classes where the topic is appropriate and as a part of an established curriculum. Again, that's why I said it might be appropriate. They should also make sure that discussions are age appropriate. What might be appropriate in the college setting or in the high school setting may not be appropriate in the elementary school setting. And that such discussions do not promote or advocate for a particularized viewpoint that is not supported by the curriculum. Teachers and faculty should also be reminded that any curriculum-related political discussions should be presented to students in a purely informational way, and there's a way to do that. As a teacher might not or should not advocate for their own personal viewpoints before a captive audience. And should a teacher ignore these directives after you've gone through this analysis to hold only informational, curriculum and standards-based discussions with students regarding current political topics, you probably have a situation where the school district is more justified in imposing disciplinary action. Something that we started to see in 2020 and we expect to see more of is, what if this bleeds over into a walkout? It's not just a posting, it's not just a discussion in the classroom. What if students or staff, or students and staff, plan to participate in a protest or a walkout in support of some cause, concern, or demand for change? Again, as you re-examine your policies, you want to make sure that all staff and students are held to school district's current policies and procedures for attendance. So again, what you're not doing here is disciplining based on content or content and expression related to some speech concern, but simply attendance, which should be consistently applied in the non-content-based arena as well as in the content-based arena. So staff members generally are expected to work their entire workday to do the jobs that they're paid to do, including any routine after school duties, any after class duties, unless they are approved to take leave. Staff members who leave work early to participate in a protest or a walkout may be subject to disciplinary action. Likewise, students should not be allowed to leave school to participate in a protest or walkout unless they are properly excused by a parent or guardian in accordance with the school's attendance policy. But again, we do not want to more harshly impose discipline on students or staff because they've engaged in some content-related action. Now, the other thing that we have all around us are emails. Teachers and staff use emails for all types of purposes. So what if students and staff use district email, district equipment, school equipment and email to organize a protest or to solicit participation in a protest? Again, here, school districts should now re-examine their technology policies for staff and students to determine whether school resources, email, devices, other equipment may be used in this manner, or if there are clear policies which prohibit it. So technology use policies may prohibit the use of district email and equipment for sending political and campaign materials. However, school districts should ensure that any prohibition against using district email for political purposes does not actually interfere with an employee's right to engage in protected concerted activity. So again, there's still a delicate analysis that must be done in light of the First Amendment framework and principles that we have available to us. So we have a number of questions that we could answer like this. What if staff wears school paraphernalia or district paraphernalia to a protest, but it's off campus? What if they wear these things and they are somewhere not on school grounds? Arguably, it could look like if a staff wears school district or school paraphernalia, t-shirts, hats, even masks, that they are somehow being a representative of the district. But before districts jump to somehow discipline for that, you really want to look at the fact that wearing that shirt itself, wearing the paraphernalia, is a form of freedom of expression. But is it one that is outweighed or that should be discussed with the staff member because they have now given the appearance that they are representing the district or the school or the campus in some off-campus, unrelated, unaffiliated protest? I think in this sense, you can certainly go through the analysis, but we don't want to discount the practical approaches, which may be for districts to remind school staff, to remind faculty of the perception that's created in understanding that, yes, we understand that you have your right to speech and you have your right to protest, but there is a perception that is created when you wear school and district emblemated or paraphernalia, shirts, hats, jackets, things like that. So a proactive discussion with school staff serves to protect both the school and district individual employees. And it can lead to open discussion as to whether people understand policies, whether they're understanding what their rights and responsibilities are as private citizens and as public citizens. What about social media? How do campuses and school district administrators handle comments on social media, Twitter, Facebook, Instagram, TikTok? There's so many platforms, they're growing. We can't imagine to capture and know all of what they are, but we know that our students and staffs are actually using them, and they are commenting on matters that we may not find to feel warm and fuzzy. They're critiquing administrators, they're critiquing strategies, plans, and they are expressing their opinions in large numbers, and we don't expect that to go away. So by choosing to allow public to post comments if there's a district's official page or a school's official page, we can say that a school district or a college campus has likely created a public forum for First Amendment purposes. In that case, if a public forum has been established, the result is that a district should not and cannot discriminate on the basis of an individual's viewpoint when administering that public platform, whether it's a Facebook page, Twitter, or some other board maintained or school district maintained page, by removing comments that feel obscene or that they feel are likely to are racist or hate speech or offensive. You can't remove those that you don't like and keep the others that you do. If a school district is actually concerned about the challenges of monitoring comments on their page, then the alternative is to set up a page that's non-interactive, where no comments can be posted, but it only allows as a filter or a receptacle for information that the district or the college wants to actually put out in the community. Speech is powerful. We know that from a number of the case examples that we have seen and a number of things that we know that you're experiencing right now in your organizations with your staff and with your students. It can stir up action. It can move people to tears, both joy and sorrow, and both inflict great pain. We cannot react to that pain by punishing the speaker. As a nation, we have chosen a different course to protect even hurtful speech on public issues to ensure that we do not stifle public debate. These are words, and this is an exact quote from the Supreme Court case of Snyder versus Belk. Our courts have recognized over and over again that there is also no question that the free speech clause protects a wide variety of speech that listeners may consider deeply offensive, including statements that impugn another's race or national origin, or maybe even denigrate religious beliefs. So, as we talked about the test for limiting that speech, whether or not it's likely to substantially disrupt the educational program, courts have also said that there must be a compelling interest in promoting an educational environment that is safe and conducive to learning, but with the caveat that a school must provide a particularized reason as to why it anticipates substantial disruption from speech sought to be prohibited, or you find that something is going to disrupt the educational environment or the program for the worse. Otherwise, you could find yourself infringing upon students' free speech rights. I want to talk about just a couple of cases that have struck down some of these policies again. There is the case from the Seventh Circuit, a 2011 case, Zamnick versus Indian Prairie School District number 204, and I'll give you that site if you'd like to look at that. It is 636 F3D 874, and again, that's the Seventh Circuit 2011. And in that case, the Seventh Circuit struck down a school policy prohibiting negative comments about homosexuality, stating that a school that permits advocacy of the rights of homosexual students cannot be allowed to stifle the criticism of homosexuality. So in that case, without evidence that the school had a reasonable belief that it faced a threat of substantial disruption, so again, relying on that Tinker test, the speech restriction in this case could not be justified. The court found that here, disruption cannot result from the response of the listeners, which means that retaliatory conduct by the persons offended by the speech in question does not provide a grounds for suppressing the speech, no matter how offensive it may seem. If suppressing speech in the school setting raises constitutional questions, even more concerns exist with regard to efforts to regulate speech outside of the school setting. We have all seen ourselves go from a virtual environment to a partially virtual environment to some still remaining and deciding that as we go back, we need to create specific virtual environment spaces because everybody's not ready to emerge from what considers to be an ongoing pandemic. And while the law on this topic of what happens in the virtual environment and what capacity school districts and colleges have to regulate that is still developing, the Supreme Court did issue an opinion last week that addressed this topic. It doesn't answer all the questions that we may have, but it certainly addressed the topic. And that case, on June 23rd, 2021, the United States Supreme Court issued its decision in Mahanoy Area School District versus BL. And in that case, BL was a student at the Mahanoy Area High School, and she cheered on the junior varsity during her freshman year. Now, when she didn't make the varsity school her sophomore year, she posted a photo to Snapchat of her and her friend holding up a middle finger. We all know what that means. And she captioned the photo with multiple uncensored expletives. She posted a second message where she referred to cheerleading, but not including profanity. Some of her Snapchat friends shared the post. As so often happens, things happen outside of our purview. We don't know what's happening, and friends share it so that it makes its way onto campus and in the platforms that we share. But it was removed she was removed from the cheerleading team for these posts. So she appealed within the school system, and her appeals were denied. She then filed a federal lawsuit alleging that her First Amendment rights had been violated when she was disciplined for what she called her purely off-campus speech. The district court held in her favor, finding that even if the school could regulate off-campus speech, her messages were not sufficiently disruptive to permit the school to discipline her. The school district appealed to the U.S. Court of Appeals for the Third Circuit, which held that schools may not discipline students for off-campus speech unless the speech was not protected by the First Amendment. The school district appealed to the Supreme Court. The Supreme Court, of course, took the case, and here we have this opinion. Now, the court first disagreed with the Third Circuit that schools may never regulate off-campus speech, but the court said there are some situations, bullying, for example, that call for intervention by schools. And the computer-based learning environment makes it difficult to assess when on-campus speech becomes off-campus. The court stated it could not predict all of the circumstances in which regulation of off-campus speech would be appropriate, but instead stated simply, for this case, which is why I say this case doesn't answer all the questions we may have, I still find it to be very factually specific, but it stated that simply the leeway the First Amendment grants to schools in light of their special characteristics is diminished with respect to off-campus speech. So what the court set up here is that if it's purely off campus, it is diminished, but there may be circumstances where a court may regulate. And there are some cases that came before this 2021 case, not in the Supreme Court, but in our courts of appeals, where there are some different decisions, where courts have allowed school districts to discipline and have upheld the discipline that has occurred, and that is seemingly purely off campus. But in this case, the court looked at several factors: that this speech was off campus, it was online, it did not identify the school, and if this person had been an adult, if BL, the student, had been an adult, her speech clearly would have been protected under the First Amendment. And the court also noted that here the school system had failed to show any disruption in the learning environment. So where does this leave our school systems today? It leaves us in the place that brought us here, together to discuss this topic. The effect of this decision is that school systems and institutions of higher learning should be careful when regulating speech, any off-campus speech. And so there are still circumstances, of course, as the court stated, where it may be appropriate to do so. Speech that occurs during a school-sponsored event alone, or during online learning, or that causes a disruption to the learning environment, might still be appropriately disciplined. So as you see, the trend here is that we're still relying on those three principles that I introduced at the beginning of this webinar as we're looking at the events of the day. So what do you do in responding to protest post-pandemic as schools reopen? There are a couple of practical considerations, and there are some best practices that you can employ to make sure that you're ready and you're taking a proactive stance as your students are returning to these in our institutions of higher learning and our K-12 context. Our first priority, of course, is keep students safe. As a practical matter, maybe an administration recommends alternatives to speech. There should be ways in which administration is communicating, whether it's on a local administrative level, like a principal or counselors or assistant principals, that we have ideas of what's being planned by faculty and students, and that we're encouraging open conversation so that we can address things as they come. Stay neutral. However, whenever things arise, the best practice for our administrations is to stay neutral, not take a side. And attend to students who remain. They don't walk out. They don't participate. They're very focused on simply learning and not expressing viewpoints in the way that others are. You still must attend to those students. However, counsel, as I stated, should be consulted when questions arise. So I want to share with you just a couple of guidelines that you may use and employ in trying to determine whether particular conduct is appropriate. So guiding legal principles, you want to consult with your counsel on, first, offensive speech. We know that offensive speech is often protected. Freedom of speech is closely guarded by courts, particularly when the nature of the speaker's message is controversial. Where that looks like in practice is maybe you've invited a speaker, maybe a student group or an organization has invited a contentious and a controversial speaker. You want to employ those analyses, speak with legal counsel, partner with them so that there's not a very quick and emotional, fast pulling of the trigger. Most types of offensive speech, understand and remember, or appropriate speech occurring off campus on non-K-12 or university-sponsored web pages online are also protected. Even student posts on sites like Facebook, Twitter, I understand, rate my professors, review the college, great schools, there may be comments there and those may be protected. Some speech, such as harassment, however, obscenity, defamation, true threats, which is unprotected, may still be disciplined in the university context, in the K-12 context, because you're not imposing discipline because of the content of the speech. There are other areas of law and prohibition that we're looking at. So practical guidance when dealing with inappropriate speech and working with your counsel is work with the students to create communities that discourage offensive or harmful online speech. That can be infused in your missions. That can be infused in orientations to the school and to online learning, the expectations, rules and norms in classrooms, get buy-in from students. However, we understand that this doesn't always work. And so in cases where this doesn't work and these voices are drowned out by reason, you want to employ your university council, your school council, your general counsel to help you determine what type of speech or what form is at issue, where the discipline might be imposed. This determination requires legal expertise, and it often defines your ability to respond and to discipline and not find yourself in a lawsuit. Even where speech does not meet your reasonable standards of conduct, again, it may be protected, and we can't emphasize that enough. However, again, we talked about threats to violence, those things that courts have said are not protected as First Amendment speech. So what do? At the same time you're reviewing your policies, look at your regulations. Look at regulations that may result in inhibitions of free expressions and free speech. Revisit those. And while you may determine that speech does not comport with your academic goals, it doesn't mean it's not protected. So when you're drafting regulations, when you're looking at your policies, even if you're looking at drafting new regulations and policies, you should be aware that there are certain phrases that we can look at. Your counsel can work with you to write those policies, review those that have already been judicially struck down that we can look at as guidance. So for example, a regulation that prohibits advocacy or unlawful action by an outside speaker will likely be deemed invalid. And that is particularly at play as universities and college campuses tend to have the most context of inviting outside speakers to speak to the school community. The mere presence of a controversial person on campus as an incitement is likely an insufficient basis to impose a restriction on that speaker's attendance. Another problematic regulation that you want to avoid is the type which prohibits generically and generally overbroadly religious services on campus. So while such a ban may be constitutionally permitted, if not required, only religious services can be banned in looking at whether you have restrictions on funding, whether you are restricting other types of content-related speech that is just not strictly related to religion. However, we know that there are some other constitutional provisions, the Establishment Clause, the separation of church and state that may come at play. But again, these are all things that you want to look at and talk to with your counsel as you're considering these things. In general, what we're advising you to do here is look at your approach, look at your response carefully, look at your policies carefully. Consider the type of environment that you're regulating, whether it is the K-12 context or the university campus. Look at whether it's a public college, whether you're a private university. What are your missions? What are your goals? What have you set forth to your school community and your surrounding stakeholders? We hope that this has helped you in determining what you can do, what you can't do. We know the line these days between on and off campus speech is not that clear. We know that there are connections to off-campus speech and on-campus speech. We know that faculty, they don't drop their First Amendment concerns at the door like our students don't. You already have policies in play, and we are here to help you review those, to discuss scenarios, things that you know that may be brewing, things that you may be seeing in email, things that you're hearing your faculty talk about, things that we know are concerns. We thank you for joining us here today. And if you have any questions for us, we hope that you will reach out to us here at Nelson Mullins. And we thank you for joining us here for this webinar on post-pandemic protests and helping you to get prepared. Thank you.